We now proceed to our fifth keynote speech of this conference. Please give a big hand to welcome the Honorable Justice Huang Ruiming to host the speech.
Good afternoon. Dear honorable guests, I am pleased to host the fifth keynote speech section for you. The subject for this fifth keynote speech is the role and authority of the European Court of Human Rights. The subject will be addressed by Professor Dr. Andrzej Jemczewski. Dr. Jemczewski teaches in both the International Institute of Human Rights in Strasbourg and the University of Middlesex in London. Dr. Jemczewski lives in Strasbourg, where the European Court of Human Rights is located. Please join with me to welcome Professor Dr. Jemczewski.
Good afternoon, ladies and gentlemen. A great privilege for me to be here today. Thank you very much. The role and authority of the European Court of Human Rights. The European Court of Human Rights was created back in 1959, and it will celebrate its 20th anniversary of existence as a full-time court in Strasbourg on the 1st of November this year. Rather than provide you with an analysis of the court's case law, there's an edition of an outstanding book on this subject, which has just been published by the OUP. Come back to it later on. I intend to present to you a much wider picture of the court's role and authority as the institution which possesses the final say in interpreting and applying the substantive provisions of the European Convention on Human Rights, by which all 47 member states of the Council of Europe are bound. My presentation will consist of three parts. First, I'll provide an overview of the court's role in Europe's changing architecture. The second part will deal with the gravitas, the importance of the Convention and the court's case law, the importance it has acquired, as well as the challenges it is facing. And the third part will focus on an assessment of the manner in which the system operates, with emphasis being placed on the responsibility of states to consolidate and reinforce the Convention's effectiveness and the Strasbourg Court's authority. I will then finish the presentation with a few concluding remarks in which I'll suggest a rather slight readjustment accommodation of the Convention without any major structural change. Part one, the court's role in Europe's legal architecture. Drawn up within the Council of Europe, the European Convention of Human Rights came into force on 3rd September 1953, when 10 of the 15, at the time principally Western European member states, ratified it. This international instrument represents a collective guarantee at the European level of principally a list of civil and political rights guaranteed by the UN Universal Declaration of Human Rights of 1948. At the time of its adoption, it was considered primarily as a collective pact against totalitarianism in Europe. After the rise of Nazism and fascism, and in particular the atrocities of the Second World War, we Europeans are, quote, guilty of both world wars. Like-minded European states came to the conclusion that in order for history not to repeat itself, the mechanism to protect individual rights on the international plane would need to be established. The instrument was not intended to create new substantive rights. It was designed to place under international supervision basic common rights and freedoms already well entrenched in the domestic law of states parties. This newly established mechanism made a departure upon reliance on traditional international law concepts of nationality, everyone within the jurisdiction, and reciprocity, the Convention as a law-making treaty, in order to protect individuals. But the revolutionary innovation at the time was the possibility of individuals to bring complaints against states on the international plane and the compulsory jurisdiction of the court, at the time based on a tripartite system of control by a Human Rights Commission, a court, and the Committee of Ministers, the executive organ of the Council of Europe. In other words, individuals from states having accepted the optional procedure were, after making all use of all domestic remedies, were able to seize the European Commission of Human Rights, but not the court. So what led to the creation of a full-time court in Strasbourg in 1998, and what are the main challenges facing the court? The answers are well known. It was the enormous increase in the workload of the bodies responsible for enforcing the rights guaranteed by the Convention, plus the unforeseen increase, both potential and real, in membership of the Council of Europe after the fall of the Berlin Wall in November 1989. The part-time commission and the part-time court were abolished. The system was streamlined. All individual applicants now have direct access to the court, and the right of individual petition is mandatory. The court has also jurisdiction with respect to interstate cases, and the Committee of Ministers, the political organ of the Council of Europe, no longer can decide on merits of cases. Permit me to recall in this connection that in 1949, the organization had 10 member states. In 1990, it was 23 member states, all of which had ratified the Convention, fully accepting the control mechanism. Since then, all states prior to joining the organization had to undertake a commitment, a political commitment, to ratify the Convention within a short time after accession to the Council of Europe. Today's membership of the organization is 47 states, all of whom being parties to the Convention. The challenges facing the court in Europe's new legal architecture are considerable. One can identify at least two interrelated reasons for this. The court's enormous workload. As of June of this year, 54,350 applications are pending before the court right now. And the weight, complexity, and above all the type of major human rights problems the court is confronted with, principally, but not exclusively, from the so-called new democracies, especially those of Eastern Europe and the former Soviet Union. There has been an unprecedented, one could say indeed an astronomical rise in the court's case law. Between 1958 and 1972, the court delivered on average 1 judgment a year. The yearly average between 1981-85 was 11. 2004, 718. 2017, last year, well over 1,000 judgments rendered by the court. We must also be honest and accept that the Council of Europe of 47 member states is no longer the privileged club of a relatively sophisticated and economically more or less comfortable states which reflect liberal Western European democratic standards. The rapid enlargement of the organization poses today a serious threat to the Convention's acquis. Legal standards in several new democracies, we must be honest, fall far short below those required by the Convention and the Court's case law. The Court continues to be confronted with an extremely difficult balancing act. High human rights standards need to be maintained in the old democracies, and at the same time substantially improved in a number of newer states parties whose democratic credentials are suspect, not to say defective. And this brings me to the end of my first part of my intervention with a question. What exactly is the court's role in Europe's evolving architecture? My answer, the court has in effect a dual role. That of the right of individual application, which remains the linchpin, the indispensable tool of the Convention enforcement mechanism, without which the system would almost certainly fall apart. The Convention is also, to use as underlined by the Court itself, a living instrument whose primary purpose is to ensure l'ordre public de l'Europe. In a way, the Court possesses a quasi-constitutional role in upholding common basic human rights norms which need to be interpreted in the light of new and constantly evolving societal norms and expectations. The Strasbourg control system is subsidiary. It's a safety net in that states themselves have the primary responsibility of protecting human rights. My second part, a few words about the authority of the Convention and the Court's case law. the Convention and the Strasbourg Court's case law have brought about major modifications in the laws and practices of all the 47 member states of the Council of Europe, without exception. Several states have made changes to their legal systems prior to or shortly after accession to the Council of Europe in order to bring them into conformity with Convention requirements. For example, Switzerland in the early 1970s granted women rights to vote at federal level before ratifying the Convention. Also, in the course of the political changes of the 1980s and 1990s, several post-Soviet states abolished the death penalty, as I had explained briefly this morning, and substantially restricted the overbearing role of the Procuratura, prosecuting authorities as we now call them. Areas in which the Convention and the Court's case law have brought about significant changes include, I list them, individuals' access to justice and the right to fair trial, prohibition of discrimination, property rights, family law, issues such as custody, the prevention and punishment of torture, protection of victims of domestic violence, privacy of individuals and their correspondence, protection of religious rights, freedom of expression, association. The Convention and the Court's case law has profoundly affected all areas of human life, benefiting hundreds of thousands of individuals, associations, political parties, companies, and persons belonging to many vulnerable groups, such as refugees and asylum seekers, and those belonging to national, ethnic, religious, sexual, or other minorities. Also, the Convention is part of domestic law of all 47 contracting state parties, at a constitutional and above constitutional level in certain of those countries. However, despite the undoubted success of this regional human rights mechanism, the Court's authority is confronted with challenges and threats. In addition to the considerable docket of complex interstate case law relating to, for example, human rights abuses committed in the conflict concerning the Ukraine and Russia, or the massive human rights violations recorded in the North Caucasus. The Court must deal with major structural problems in several countries, such as excessive length of judicial procedures in Italy, Romania, Hungary, Bulgaria, unacceptable conditions of detention facilities, principally but not exclusively in the countries of the former Soviet Union, as well as non-enforcement of domestic judicial decisions, for example, Russia, Ukraine, and excessive length of remand detention, and in particular again, Russia and Turkey. The massive and constant arrival of migrants, refugees and asylum seekers in Europe, and the flood of applications linked to the failed coup d'etat in Turkey also pose significant challenges for the Court. The picture is actually rather grim. In 2017, more than 20% of violations found by the Court involved serious breaches of the right to life and not to be tortured. Now, after the fall of the Berlin Wall, the somewhat precipitated and yet politically inevitable decision was taken to, as it were, force states to ratify the Convention within a very relatively short time span after joining the organization, thereby extending the Court's jurisdiction to states lacking adequate democratic credentials and a solid rule of law base, on the understanding that Convention standards would not be diluted. Now, we accept the premise that views differ as to the correctness of this political decision. That said, one cannot deny that it has been an uphill struggle and that the result in certain instances is far, far from satisfactory. This difficult situation has in recent years been compounded by gratuitous, I would call it, Strasbourg Court bashing in certain of the old democracies, the UK, I have a UK nationality, and in an attempt to undermine the Court's authority by destructive legislative initiatives taken by, for example, the Russian Federation in 2015, which empowers the Russian Constitutional Court to determine inter alia whether the findings of the Strasbourg Court are compatible with the Russian Constitution. But these negative comments must not detract from the staggering achievements accomplished by the Convention control mechanism. If you permit me, my paper is much too long, the written one, if you permit me to refer to two subjects which are of particular interest to me, namely the Court's interpretative authority and the European Union's non-accession to the Convention. The Court's interpretative authority. Now, we can all agree that it is totally unacceptable for the Strasbourg Court to continue to deal with, again and again, similar violations that occur in different countries, even though the meaning of Convention standards is crystal clear on the basis of well-established case law of the Court. And yet, to my regret, this actually still often occurs. Permit me to cite in respect one case, the case of Marx against Belgium of 1979, in which the Strasbourg Court held that children born out of wedlock must not be discriminated against. French law had similar discriminatory provisions, and yet changes in the French legal system were only effectuated 20 years later, after France had been found in violation by the court in the year 2000 in the case of Mazurek against France. The point I'm making here is actually quite simple. Although the Strasbourg Court judgments are binding on those states found in violation of the Convention, inter partes, state authorities, be they executive, legislative, or judicial, are duty-bound when having cognizance of such cases as the case of Marx against Belgium, to take into account the court's interpretative authority, res interpretata, in respect of judgments concerning all states. The res interpretata authority of the court's case law has now been recognized by a number of national highest judicial authorities, for example, in the Netherlands, as well as in specific legislative provisions in a few countries. For example, in the United Kingdom, the Human Rights Act of 1998, it specifies that national courts, quote, must take into account, unquote, the Strasbourg Court judgments, and Article 17 of the Ukrainian law of 2006 reads, I quote, courts shall apply the Convention and the case law of the Strasbourg Court as a source of law, end of quotation. But much more needs to be done on this. In this connection, the entry into force of the 16th protocol to the Convention on the 1st of August of this year, not long ago, which provides for the possibility the highest domestic courts to seek advisory opinions on, I quote, questions of principle relating to the interpretation and application of the rights and freedoms defined in the Convention, end of quotation, in cases pending before them, is likely to contribute significantly in asserting the court's unique role as the final authoritative interpreter of the meaning of the Convention's substantive provisions. Accession of the European Union to the European Convention on Human Rights. Article 6, paragraph 2 of the Treaty of the European Union, it stipulates that the EU shall accede to the Convention. On the basis of this provision, a draft accession agreement was agreed in the year 2013 between the European Commission and the Council of Europe member states. However, as many of you are aware, negotiations with respect to EU accession will need to be reopened after the Luxembourg Court's negative opinion in December 2014 on the agreed text. Now, without reopening discussion on this point, on this subject today, what is important to bear in mind is the intrinsic logic of such accession, an international organization being a party to the Convention of Human Rights, especially as all the presently 28 member states of the European Union are also bound by the Strasbourg Court judgments. Also, although the European Union has its own Bill of Rights, the Charter on Fundamental Rights, primary law, accession would submit the European Union's legal system to independent external review, permitting individuals to bring complaints of alleged infringements of the European Convention of Human Rights by the European Union itself for acts or omissions for which the EU now often has exclusive responsibility. It would fill a gap. Moreover, accession would achieve a coherent system of human rights protection in Europe, excluding the possibility of forum shopping, and ensure a harmonious development of European human rights law by the court in Strasbourg. A few remarks to conclude the second part of my intervention with respect to the court's authority. The court is the final authority for the application and interpretation of the Convention and a constitutional instrument of European public order. That said, the challenges facing it are substantial, principally but not exclusively relating to large-scale abuses of human rights and the existence of persistent, systematic, unresolved human rights violations, which, when not dealt with by states at the domestic level, they clog up the court's work in Strasbourg. At the start of 2017, the court had 80,000 applications pending before it. The number stood at 56,000 at the beginning of this year. Now, although this is a major drop in numbers, the situation remains unacceptable. In addition to the major human rights violations in its docket, one cannot but be deeply saddened and indeed frightened by the rise of the illiberal democracies and the erosion of rule of law standards in countries like Romania, Hungary, and Poland, which we referred to this morning. These must now be dealt with by the European institutions and other Council of Europe political bodies. To my regret, the Strasbourg Court will almost certainly not be in a position to deal with these issues in the coming years. Exhaustion of local remedies, time, etc. The real world. Thus, this is also true of the repression of the freedom of speech, mass arrests, and civil society in Turkey in the context of the state of emergency and beyond. The above developments pose a new and grave challenge to the court's authority. Hence the need to further consolidate and reinforce the system's effectiveness, which I will now deal with in my third and last part of the intervention. States parties to the Convention have undertaken to abide by judgments of the Strasbourg Court, and it is the Committee of Ministers, the executive organ of the Council of Europe, which is the foreign ministers of the member states, which supervises the implementation of the court's judgments. States are duty-bound to ensure full, effective, and prompt compliance of all judgments, including those which raise substantial structural problems, often necessitating, as already explained, legislative amendments and administrative reforms. In the majority of cases, this is all done within a reasonable time, where the court has found a violation. Indeed, one can probably consider it as a major achievement, not to say actually a small miracle, to note that in 2017, nearly 3,700 cases have been satisfactorily resolved before the Committee of Ministers after violations found by the court. The figure was 2,066 in the year 2016. Nevertheless, although the overwhelming majority of Strasbourg Court judgments are implemented without difficulty, it is still highly disturbing to observe that there were nearly 7,600 unresolved cases pending before the Committee of Ministers at the end of last year. Of considerable concern is the fact that serious structural problems remain on the Committee of Ministers' docket for over 10 years. Yes, 10 years with respect to 10 countries, namely Italy, Russia, Turkey, Ukraine, Romania, Hungary, Greece, Bulgaria, Moldova, and Poland. Can one honestly deduct from this that these states, together with several other of the court's main clients, have made serious efforts to comply with the court's judgments? Easy, the question is there, but how best to deal with this problematic situation? Ought not the principle of state responsibility be invoked to a greater extent before the Committee of Ministers and some sort of sanctioning mechanism applied? In my written paper, I go into that a little in detail. I will restrict myself to saying that when touching upon the notion of state responsibility, it must be emphasized that all branches of state responsibility, all branches of the state are responsible for implementing European human rights standards, not only governments, and not only government. The rapid and full implementation of Strasbourg Court standards rests on the shoulders of the executive, the legislative, and judicial organs. In this connection, I wish to highlight one recently relatively neglected aspect, namely the need for more structured and systematic involvement of state legislatures, state legislative organs, a subject which has not been given sufficient attention. Permit me to highlight a few self-evident points in this respect. Members of Parliament hold governments to account when implementing legislation, approve, ratify treaties. They are also intricately involved, are they not, on a yearly basis in the determination of the state budget. Hence, insofar as the ECHR is concerned, parliaments can influence the direction and priority of legislative initiatives and, when appropriate, channel the funds needed to ensure prompt implementation of Strasbourg Court judgments. Now, in this connection, the Parliamentary Assembly, the other organ of the other statutory organ of the Council of Europe, has urged all parliaments to set up appropriate structures and mechanisms. Few, unfortunately, have done so. Also, a few words about the budgetary situation. At the beginning of this presentation, I referred to a recently published book. Its entitled is Law of the European Convention of Human Rights, 4th edition, just published recently by the OUP, which provides an in-depth analysis of the Strasbourg's case law. In the book's preface, mention is made of recently imposed cuts on the court's budget following political decisions by Russia not to pay its budgetary contribution to the Council of Europe and by Turkey to reduce its contribution considerably. Now, be that as it may, permit me to be somewhat blunt and undiplomatic. I'm no longer a civil servant, I'm a free agent at last. Now, despite repeated praise of the court's, quote, extraordinary contribution at many high-level conferences of foreign ministers of member states of the Council of Europe, and highlighting the court's, again I quote, essential status in guaranteeing the protection of human rights in Europe, how many persons today, in today's audience, are aware of the fact that the contribution of 15 states, 15 of the 4, in other words, almost a third of the organization's membership, pay into the Council's ordinary budget a sum of money, a contribution, which does not even cover the cost of the emolument of their national judge. 15 states pay less than it costs to maintain the judge in Strasbourg. My concluding remarks. I must be honest with you and indicate that the issue of questions of the court's legitimacy have in recent years surfaced, including in the old mature democracies. And this includes problems of divergence of Strasbourg Court's case law with that of state supreme and constitutional courts. One way to, in my view, partly abate this criticism would be, I suggest, to permit the highest courts in states concerned to designate a senior judge to replace the national judge in cases determined by the Strasbourg Court's Grand Chamber. This would, if you like, enhance the interaction between domestic courts and the court in Strasbourg and create among the domestic judges a feeling of ownership and more sensitivity towards Strasbourg case law. So, how best to commemorate the 20th anniversary of the full-time European Court of Human Rights in less than a month's time on the 1st of November? In my view, by simply firmly reaffirming the uniqueness of the Strasbourg Court's dual task, the Court's key role in adjudicating individual cases, providing justice of last resort to individual applicants, and confirming the Grand Chamber's authority in upholding the Convention's specific characteristics as a constitutional instrument of European public order. I thank you for your attention.
We thank Professor Dr. Andrew Demczewski for his insightful speech.